I'd like to thank the Backbench Business Committee for giving me this chance to talk in particular about the Child Maintenance and Enforcement Commission, or rather one element of it, the Child Support Agency. In the Borough of Charnwood, there are currently 2,000 cases being handled by the CSA, and I'm sure many colleagues across the House have a similar workload. Despite the best efforts of staff that we have dealt with in my office, it is clear that the CSA is not working and seems to embed conflict between separating parents. It costs £460 million per year, or 40 pence for every pound collected. And on a day when the government is talking about social mobility, we must ensure that organisations such as the CSA do not play their part in hindering the life chances of those children who are relying on them. I welcome the approach in the government's Green Paper of not considering child maintenance in isolation, but instead working with the Department of Education and the Ministry of Justice as part of the Family Law Review. I particularly feel, however, that based on the cases I'm going to mention, with their permission, that access to children for whom maintenance has been negotiated cannot be sidelined. My main reason for speaking today in the brief time available is that I wanted to give a voice to some of the parents who have contacted me about the CSA since my election last year. I realise there are two sides to every case, but I think these particular cases highlight why changes in the way child maintenance is collected and calculated are needed. I want to concentrate on three particular areas: enforcement, charges for those who have to rely on the state system, and the need to look at the whole picture of the families involved. One of my constituents, Mrs Denise Kuzniar, has been receiving child maintenance payments from her ex-husband through the CSA for the past 11 years. However, the payments are intermittent, sometimes stopping for several months at a time, and she is now currently owed £2,300 in arrears. She is in a growing amount of debt as a result of this situation. She has 2 teenage children to look after and is really struggling to make ends meet. I've had several conversations with the CSA about this issue, but no serious enforcement or action to remedy this situation has taken place. Any reforms, therefore, to the statutory system evidently need to include much more stringent enforcement provisions so that parents in care do not have to go through the pain and uncertainty that Mrs Kuzniar has suffered. Second, she is already struggling with supporting her family, and it will be all but impossible for her to reach a private maintenance agreement with her ex-husband, given the continued attempts to avoid making payments through the CSA. Under the government's proposals, it would appear, therefore, that she would have to turn to the statutory system and potentially incur a charge on a case-by-case basis. This would be devastating for her, given the number of times her case has had to be reassessed by the CSA due to her ex-husband's actions. I've been contacted by many other constituents who have faced similar difficulties and for whom the thought of making private arrangements with their ex-partners is unfathomable, and so they again would have to turn to the state system. One ex-partner has been requested to pay only £5 per child, but instead he seems to do what he can not to have to pay her anything. There is a risk, therefore, that under the government's proposals, vulnerable parents, like those just mentioned, will be forced to turn to the statutory system, but could be put off doing so by the thought of having to pay to access the system. I realise there are proposals to ensure the non-paying partner pays charges, but this must be made clear to all involved, as it is clearly causing a great amount of stress and worry. Finally, I wanted to highlight some of the issues currently faced by parents making payments through the CSA. I have been contacted by numerous constituents who say that even under the current system, these payments are unaffordable and do not share the burden of responsibility evenly between the partners involved. These parents literally live on the breadline, and although they do everything they can to support their children and will be willing to come to a private maintenance agreement with their ex-partner if possible, they have been unable to do so for a variety of reasons. I particularly want to talk about the case of 2 fathers, since we often concentrate on the mothers involved. The Minister may be aware of the case of Mr Jonathan Little, who I spoke about at Work and Pensions Questions last week. Mr Little has not seen his children for 2 years, although he has been to court over 40 times to get agreement to visit. He is paying £446 per month on the old scheme for children he doesn't see. Meanwhile, he cannot afford to keep a roof over the heads of his new family. Mr Mark Boylan has been left with only £49 a month disposable income after paying the CSA and all other expenses. His assessed payment should be lower, as the CSA charge attracts a discount if you look after your children for more than 52 nights a year. However, his youngest daughter is 2 years old and too young to stay away from her mother overnight. So although he looks after her during the day and pays all expenses for her, because she doesn't stay overnight, the CSA will not give him any discount for the care. In summary, I have sought to highlight some of the major concerns raised by constituents about proposed changes to the child maintenance support system, but I've also mentioned the problems with the current system because they clearly demonstrate that reform is very much needed. There must be robust enforcement mechanisms which prevent a parent from using various means to avoid paying what they owe. There must be clarity about charging, and the system must be flexible enough to reflect both parents' income and the burden of who is taking the financial responsibility for caring for those children. Thank you.